The Supreme Court's verdict in the Ayodhya matter has settled the title suit in favour of the main Hindu plaintiff, essentially the Vishwa Hindu Parishad, but it is clear that there is so much more at stake for the country than the ownership of 2.77 acres of land on which a mosque stood for 470 years until it was demolished in an act of political vandalism unparalleled in the modern world. In this episode of Beyond the Headlines, I will decode the essence of the judgment for you and analyse what the verdict could mean for the future course of politics in India. So let me start with the verdict itself. Since there's been a lot of ill-informed commentary floating around, you need to get this straight. The Supreme Court has given the land to the Hindu side not because of the faith and belief some Hindus have that Lord Ram was born at the site of the Babri Masjid, or even because there is archaeological evidence that the mosque was built by demolishing a temple. In fact, the Supreme Court bench undid some of the dangerous logic of the Allahabad High Court, which in 2010 had given 2/3 of the land to the Hindu plaintiffs on very dodgy, faith-based grounds, and explicitly said it was deciding the title suit only on the basis of the law of adverse possession. This view of the Supreme Court is a positive step, in my opinion. The court also acknowledged the manner in which Ram's idols were planted in the mosque was illegal, and that the mosque's demolition in 1992 was an egregious violation of the rule of law. This is also a very positive development. However, this is where things go belly up, because after acknowledging that a crime was committed by depriving the Muslims of their 470-year-old mosque, the Supreme Court ends up giving legal possession to the very forces responsible for the demolition. The site will be managed by a trust that the government will set up, and don't forget that the government, until earlier this year, and the ruling party, that's the BJP, even today, have in their ranks individuals who have actually been charge-sheeted for conspiring to demolish the mosque. So what's the logic the Supreme Court followed in handing the land over to the VHP side? It said, and I find this really quite astonishing, that the Muslim side has not been able to provide evidence that namaz was offered in the Babri Masjid from the time of its construction in 1528 until 1857, when it enters the annals of colonial law thanks to a riot in Ayodhya. Sounds odd, right? The court accepts that a mosque was built in 1528 and demolished in 1992. It accepts that the Muslim worshippers were illegally ousted from the mosque in 1949. It says there are court records which indicate Muslims prayed there from 1857 to 1949. But when it comes to the 300 years preceding 1857, the court says there is no proof namaz was ever read. On the other hand, the court cites a couple of European travellers' accounts from the 18th century that Hindus in Ayodhya used to regard the site as the birthplace of Ram and pray or try to pray over there. Now, that Hindus prayed at the Ram Chabutra outside the domed mosque is well known because there are 19th century court records to that effect. But even if the court extends that practice back into the 18th century, how can the Hindu claim be stronger than the Muslim claim to a mosque that was built in the 16th century? The only way to do this is to make the curious assertion that the Muslims never bothered to pray in the mosque that was built for them until 1857. It seems absurd to settle the Ayodhya case on this basis, but I assure you, this is the logic the Supreme Court uses in paragraphs 786, 797 and 798 of the judgment to assert that the Muslims have been unable to prove exclusive possession of the site. Neither have the Hindu plaintiffs, incidentally, but that does not prevent the bench from giving the entire land to them. Now, going forward, what does this judgment mean for India? In order to answer that question, we need to understand what the Ayodhya issue is really about. For more than a quarter of a century, Ayodhya has served as a metaphor for the politics of revanchism, one which combines the deployment of a manufactured mythology around the figure of Lord Ram with mob violence, majoritarianism, and a spectacular contempt for the rule of law. The aim of this politics is to upend the Republic with its premise of equality for all citizens and replace it with a system in which India's religious minorities, to begin with, and then other marginalized sections of the population are forced to live in perpetual insecurity. If India's democratic institutions had been robust, the demolition of the Babri Masjid on December 6, 1992 should have permanently ended this politics instead of merely marking the end of its first phase. Today, that politics has reached a new high water mark, presumably not its final one, given the fillip a large section of the national media and now the Supreme Court have given it. Armed with the court's imprimatur, the Sangh Parivar will do its best to erase the taint of mob justice, which has been the strength but also the weakness of its movement. In August, BJP leaders boasted of how they had used Article 370 to kill Article 370 in Kashmir. Now they hope to use law to kill justice. We can pretend all we like that the Supreme Court was only adjudicating a civil dispute. In reality, there was nothing civil about what a judge on the bench had called one of the most important cases in the world. The dispute cannot be divorced from the politics which has driven it. The title suit in the Babri Masjid matter has been going on in one form or the other since 1949, mainly in the local courts of Faizabad, where Ayodhya is located. It took on national salience in the 1980s thanks to the cynical politics of Lal Krishna Advani, Atal Bihari Vajpayee, Rajiv Gandhi, and of course now forgotten villains like Veer Bahadur Singh and Arun Nehru. BJP leaders conspired to demolish the mosque on December 6, 1992, and a Congress Prime Minister, Narasimha Rao, allowed them to get away with the crime. Incidentally, so did the Supreme Court judges of the day. 27 years later, the demolition case continues to linger. Even when all the evidence is recorded and arguments made, the outcome is uncertain, since it's no secret that the prosecuting agency, the Central Bureau of Investigation, has willfully dropped the ball on the case. Justice S.A. Bobde was right in observing in his recent interview to India Today, shortly after being named as the next Chief Justice of India, that there have been governments of virtually all political persuasions in power at the centre since the Ayodhya case first emerged in 1949. Yet, the fact that the case ended up being fast-tracked at a time when the party in power today is one which openly asserts its partisanship on Ayodhya should be reason enough to worry us about what happens next to the Republic. We already have a draft citizenship law which explicitly excludes Muslim refugees. A law has been passed that criminalizes the abandonment of wives by Muslim men but not by men of other religions. And it's not a coincidence that the only part of India where the constitutional protections of liberty and free speech do not apply is a Muslim majority region, Kashmir. While legal analysts had expected the five-judge bench to deliver a nuanced verdict that would not lend itself to shrill triumphalism by either side to the dispute, the clarity of the court's ruling in favour of the temple side will boost the morale of the Sangh Parivar. The fact that the ruling party, and hence the government, is committed to the construction of a Ram temple at the site of the Babri Masjid means the path is now clear for speedy implementation of the project. The court has asked for the government to constitute a board, but apart from insisting on the inclusion of a representative of the Nirmohi Akhada, the third claimant to the title suit, it does not appear to have even sought the exclusion of individuals and organizations implicated in the 1992 demolition. Even before the verdict, when there was a chance that the court might uphold the Sunni Waqf Board's claim, there was never any question of the Babri Masjid being rebuilt at the same site. Had they won, there would have been enormous pressure on the plaintiffs to give up their claim to the land. Indeed, in the fag hours of the Supreme Court's 40-day hearings, the Waqf Board chairman signed on to a controversial mediation proposal under which he consented to the withdrawal of the appeal against the High Court judgment in exchange for assurances that no other Muslim places of worship would be taken over thereafter. Of course, the other Muslim plaintiffs immediately cried foul, but the fact that the main Hindu plaintiffs, essentially the VHP, were not even prepared to sign such an assurance is a sure indication that this most important case in the world will likely be followed by others. The Supreme Court has asked the government to allocate 5 acres for the construction of a mosque at a suitable place in Ayodhya, forgetting that the case's significance was not about the availability of a mosque, but whether it is permissible for anyone in India to use violence to dispossess a person or a community. Sadly, that question now appears to have been answered implicitly in the affirmative. Worse, the dispossession has been acknowledged and compensated with 5 acres elsewhere, but those who did the dispossessing are still allowed to enjoy the benefits of their crime. In my view, the fact that the court has cited evidence of Hindus worshipping at the disputed site as a reason for handing over possession could also open a can of worms for the country. It should be readily apparent that this logic can also be applied to other mosques which the Hindutva organizations covet. Once the Ayodhya temple has been milked of all political mileage, the Sangh could very well up the ante elsewhere. None of this should surprise us, since we were never dealing with a civil dispute between litigants operating on a level playing field, but rather a naked power play, one in which the political agenda of the so-called cultural organization, the Rashtriya Swayamsevak Sangh, is not hidden, and the biases of the Uttar Pradesh and central governments are on open display. That's also why the Supreme Court's insistence on mediation was so misplaced. Although the apex court chose to prioritize the title suit, fast-tracking it to conclusion, it is not clear how the bench intends to firewall the demolition case from its verdict on the property dispute. In his interview to India Today, Justice Bobde denied the court was attempting to legislate on matters of faith. He agreed with the suggestion that it is a title dispute, but added, quote, "The only thing is, what is the character of that structure? That is one of the issues. But even that structure doesn't exist anymore," unquote. Now, shouldn't one of the issues also have been why that structure, in other words, the Babri Masjid, doesn't exist anymore? The main beneficiaries of the Supreme Court's verdict on Saturday are organically linked to the main accused in the crime of demolishing the mosque. If the Ayodhya case is really one of the most important cases in the world, it is so because of the violence associated with it. Can this case really be settled then without punishing the leaders responsible for that violence? The 5-judge bench represented an impressive array of judicial wisdom. Sadly, their judgment offers no pointers on this fundamental question.